If something happened to you today, would your family be taken care of? Would they know what to do next? In this video, we're going to be talking about something that many people avoid or just have no information about: estate planning. And I'm here with an amazing lawyer who's going to just break it down for us. So keep watching. This episode has been shot from Serene Beauty. Serene Beauty is a team of creative hair and makeup stylists ready to make your wedding day beautiful. Apart from ensuring that they enhance your beauty, they have bridal space in 5 apartments to accommodate their bridal teams so that the day is stress-free. Stay here with your bridesmaids, take pictures, have breakfast, and start the day right. You can check out their Instagram page and book your appointment today, or use the number on the screen and get ready to celebrate love just right with Serene Beauty. Welcome, Damalie, again to the show.
I'm glad to be back.
You're about to become a co-host at this rate.
At this rate, I'm okay with that. I'm okay. Yeah.
So there are people who have not, watched the video before, so you don't know who you are. So
Yes.
just introduce yourself, and then we get into it.
Awesome. So my name is Damalie Tibugwisa. I'm a mother of 3 daughters. I'm married to 1 husband all the time. I run a commercial law firm called Tara Advocates, which is an award-winning commercial law firm. We support business owners with their legal needs. Today, I'm happy to be talking about estate planning.
Yeah. Amazing.
Thank you for having me again.
Do we need to break the ice?
I think so. It's okay. Let's go for it.
Yeah, let's break the ice. Okay. One thing about lawyers people get wrong.
There are many lawyers are liars, but I think the one that that one is very debatable. But the one that people get wrong is to think that you need lawyers only when you're in trouble. And like, oh, when they arrest me, I'll come to you. But that's not the fact. In fact, the best value from a lawyer is received when you engage them before the trouble happens, so that they help you prevent it.
Okay.
So that's one thing they
And
get
the
wrong.
lying bit, are you guys lying?
The lying bit, no. I think that what we do is not tell lies. We lead evidence as it is, or we challenge the evidence as produced by the other party. So whatever deductions are made out of that are not because of what we've said, it's just that we've done our job, and yeah, that's it.
Okay.
So we're not liars.
You're not liars. All
Yeah.
right. One food combo you love that people find strange.
Interesting. So I like my salad, my green salad with fruits. So we'll have cucumber, lettuce, but I want pineapples, apples in there. I want it a bit sweet and salty and different flavors.
I think that's not strange.
That's not
okay.
strange?
Yeah.
Okay, I'll give you another strange one. So I like my boiled eggs with mustard. I like them with mustard, avocado mashed with a bit of salt and pepper. Yeah.
That seems like really
With
cool
mustard.
thing.
Mustard, I think, is a different thing.
Yeah, it's a bit,
So I
yeah.
find it really
Okay.
interesting.
For me,
Yeah.
I put like boiled maize. I have to add like salt. More salt on
Really?
top. It's
No.
so nice.
It's supposed to be sweet.
Boiled maize.
Boiled maize is supposed to be
You
sweet.
try and add salt. I'm telling you, you'll never eat it the same again. Okay, all right. So we're here to talk about estate planning.
Yes.
You held an amazing symposium a few weeks ago. Well done.
Thank you.
And many people were thinking, estate planning, it's about real estate,
Yeah.
So we know that many people do not know about estate planning. So
Yes.
just break it down for us. What is estate planning?
Interesting. That's a good question. So when you talk about estate planning, if you are lucky, someone is going to think real estate, which is not quite it. Like real estate is part of the estate, but it's not estate planning. The other one is that people think you are inviting death, which is not true. Yeah? And I'm sure throughout this conversation, we're going to debunk that myth. But what estate planning is that you know that things could happen to you. Yeah? It could be death. Or it could be mental incapacity. We know that in Uganda we have high levels of mental health disorders. The statistics show that we about 32% of our population has mental health disorders, and we can argue about that, but that's the reality we live with. with high levels of stress, anxiety, depression, anything can go wrong. So what would happen in the event that you lost your mind, yeah? And your children need to go back to school, your family needs to be cared for, what would happen, yeah? Or if you're dead, because no one knows when they're going to be called, yeah? The Bible says that teach me to count my days, to number my days. So we do not know when God is going to call us. But we have family, we have responsibilities. So what happens in the event that you're incapacitated by mental health issues or even physically? Sometimes there are people who get a stroke. They have money, but they can't afford to, they can't get anyone to access it because they didn't do the right instruments. So what estate planning is really, is for you putting place instructions, you put in place instructions on how you want your estate to be managed, to be preserved, to be distributed in case of any of those eventualities. So that's what estate planning is. So it's not really planning to die. It's saying, this is the projection I have for my future and after, for my children, for my assets, for my responsibilities, for my businesses. This is what I would like to see in the event that I'm incapacitated. And so you lay down the tools that would help you support that plan.
That seems logical, but
it's logical.
It's like planning. How you plan for your day, you're like,
exactly.
Do this and do this. Because otherwise the day is just going to go, and so you don't want your life to just go like that. Okay. So when is the right time for someone to start planning, And many people here are either in families or not, they're not just saying a family, but when is the right time?
So let's say it like this. So if you have assets, everyone has assets, by the way. If you have clothes, those are assets, right?
Okay.
If you have assets, if you have liabilities, if you have businesses, if you have dependents, you have children, you have people that you look after. If you have responsibilities and you're above 18, it's time for you to start planning. Yes. So there's no postponing it. You have to start now, because again, like we've said, incapacitation does not call. It does not say, by the way, on this day you're going to have an anxiety attack and you're going to have to be hospitalized. A stroke does not tell you when it's coming. Death does not tell you. So the best time is now.
Guys, I hope you're taking notes there. So with estate planning, I know one of the main things that is there is the will. And then we have trust. Can you break them down for us? What is a will? Who needs it? Trust, is it for everybody?
Yes.
Yeah.
So like we said, estate planning is a plan. Yeah. So what we do is always recommend that you do an audit. You do an audit to identify what are your risks, what are your gaps, who are your beneficiaries, what are your assets, and how do you want to plan for all these variables, your responsibilities, your children, your business, how do you want to plan for them? So once you have agreed on how you want to plan them, then we will tell you the tools that are best for you to achieve that plan. So a will is one of those instruments, and a trust is also one of those instruments. So what is a will? Guys, it's not a voice note. It's not a call. It is a document. Yeah, it has to be a document. So it has to be written with you spelling out what assets you have, what liabilities you have, who your beneficiaries are, and how you want your properties to be distributed or preserved. And then that will should exactly state that you are of sound mind, because only a person with a sound mind is allowed to make it. If there's any doubt as to whether you're of sound mind, then you're required to have a psychiatric assessment, and a report should be attached to your will to show that when you made it, you actually had the mental capacity. Then, of course, you list your assets. The assets should only be the assets that belong to you.
Not like me and my husband.
No. It depends on how you hold those assets. So now, if those assets, there's something called joint tenants. So if you're joint tenants, the presumption of the law is that when one person dies, the one who survives takes that interest. So in cases of joint tenancy, because the law assumes that the person who survives is the one that takes it, you ideally do not own that property. You get it? But you can put it in your will and say this property is held by me and my husband as a joint tenants. Yeah, so depending on who dies before the other, then that will be spelled out. Then once you've listed your assets, guys, it's important to remember your liabilities. I know that Ugandans don't.
Yeah, they only want to put assets. They don't want to
Exactly. But remember that before your assets are distributed, your liabilities must be offset. So if you have a mortgage, you have to state it. If you owe someone money, you need to state it, because you might be there thinking that you have an estate when in fact it's hollow. I did letters of administration for someone whose husband had passed on. I got letters of administration for them. They went through this burden only to discover that there wasn't much, because most of the assets had liabilities. He had mortgaged most of these properties. So it's important for your people to know what liabilities you have. But also there are cases where people will come claiming, or there are cases where you have receivables. Yeah, like people owe you money. If you don't state that, then your family is going to lose out. I have a friend whose father died. Before he died, he told her, you know, these are the people that owe me money. 6 months later, these guys had not showed up to tell her, by the way, we owed your father money. So thank God he had told her, and so she could go and collect. Yeah. So you list all those things, you distribute. For the properties that need to be preserved, you can put them under a different instrument, let's say a trust, which I will get into. So once you've done all that, you can put your last wishes, where you want to be buried, who, if you have children, it's important to provide for who the guardian would be. But also one mistake that people make is to, in the will, you distribute everything, but you have children. Yeah, so you've not provided for their education. What is going to happen? So you say this house goes to this one, so the dependents then are left with a guardian who is not empowered financially. So then they start to struggle. Then, so it must be witnessed. You sign it in the presence of at least 2 witnesses who must be adults. They should not be beneficiaries, because then they don't want to give the impression that they influence the content. So you sign every page and date it. And you can change it and update it as and when you get new properties or your circumstances change. So that's a will.
So it's not for the rich.
It's not for the rich. Yeah. Everyone has a duty to do a will, because it helps you to avoid so many things that could go wrong because you didn't specifically provide for them. Yeah. So everyone needs to write a will. Okay. So what is a trust? So the will takes effect when you die. Until then, it's just a document you keep somewhere safe. So a trust, on the other hand, can take effect when you're alive or when you're dead. And this is how it works. So you have property that you don't want perhaps to distribute. Let's say you have a hotel or you have a business, and you know that this is going to give certain cash flows for your family. So you don't want to distribute, because when the will is read and they get probate, the people who are appointed as executors get probate, ideally by law they're supposed to distribute within 2 years. So it means that everything you've worked for all these years could just simply go to these people. And we know that usually for many estates, they won't go beyond 3 to 5 years. Everything vanishes, and then the children are left with nothing after. Yeah. So the trust helps to sort of guarantee that continuity. So you put these particular assets under a trust. It's like a company. It's a legal entity. It has a life of its own. You do a document which is called a trust deed, where you nominate particular people to act as trustees. So these trustees are governed by that document. So you nominate them, you give them instructions on how to deal with this property. What can they invest in? When can they distribute to the beneficiaries? Let's say from the hotel property, you need school fees for your children. So you can give them, as part of the instructions, that every term they should pay school fees from the money they collect from the hotel. And so those trustees are bound by that trust deed. And they are accountable to the beneficiaries. So the beneficiaries can hold them accountable. If you're still alive, you can hold them accountable. And so it's a legal entity. It has a personality of its own, but it ensures that that property is held for as long as you want it to be held under that particular vehicle. Work. Yeah.
So now someone may be asking, if for example, I'm putting that hotel or business
Yeah.
under the trust, they
Yeah.
have passed away. You've brought in these amazing people
Yes.
to manage. Is
Yes.
there a way they can also connive in a way?
That's a very valid question.
Yeah.
The reason they're called trustees is because you must trust them. And we know that human beings are capable of conniving. Yeah, that's why you need legal advice, because you could go to the internet and get any template and say, this is going to be my trust deed, I'm going to appoint this. But you need to think through the checks and balances for the trustees so that they don't abuse their powers. So there's a trust we did where the benefactor, the person who has, created it, said, I want rotational leadership. So his children were appointed trustees, but successively, to say, in the first 5 years, I want this one and this one to be the trustees. And then there's a clear instrument of they collect rent, this is how they distribute it, and then these are the checks and balances. And then every 5 years, you keep rotating, and then there are mechanisms of how you manage the trustees so that they don't abuse. Yeah. Yeah.
Smart. So we need legal counsel. Don't just do your own things.
Yeah. And I think what also helps is to appoint professionals as well as part of the trustees. It's okay to have a family member, but you need to look at your estate and how big it is and what particular skill sets are important. So you might find that maybe you have a family member who you can trust, who has the best interests of the other family members, but they don't have a financial background, so they won't know. They're just they are content creators, so they may not be financially literate, or they may not have the legal understanding of how this works and what. So you may find that having a diversity of skill sets that are picked from non-family members could help your trust run better. And those people, then you can actually check them much easier than family members, because when it comes to family members, it's a bit sensitive, it's emotional. But when you have an independent group of people that are accountable to your beneficiaries, then you hold them accountable to what their terms of reference say without emotions.
Okay, that's nice. So when it comes to wills, people are still skeptical. I know from your experience you have amazing examples, of what happens when people actually do not have wills. Because sometimes we see those things as far, and we feel like, this is my brother, my sister, my cousin. Oh, we love each other. But then that time comes and things are like changing.
Oh my God. Oh, Lisa. By the way, if people really knew that the thing that stands between them and a family dispute is a simple document, they would do better. Because it's not to say that when someone has a will, there are no disputes. But most guaranteed, without a will, you've just exposed your family to disputes. Because, so this is what happens. When you don't have a will, first we wait a bit to find out if someone will come out of the blue. So now while we're waiting, what is happening to the estate? And rarely do people do wills and don't have their things in order, because the process of doing a will requires you to sort of put your documents in order, to keep your titles in a great place. So when you don't have a will, we don't even know where to start. There's a family that we support, and what's unfortunate here is that the person who built this estate didn't leave a will, but their children were abroad. Who were they always with? The driver, the surveyor. Now we're dealing with a legal battle where the children came back. They are trying to get back what their mother worked hard for, but the surveyor and driver connived and sold off most of these properties. Unfortunately, she had even signed transfer forms. Some of them transfer forms, they had copies of her ID. So they started transferring, as soon as she died, they started transferring these properties and selling them off. We went to inspect to just find out, because eventually one of them got details of some of the properties. We didn't even know where to start. Like, let's say they tell you, go to Ginger, to this particular place. But how do you even identify the plot number, block number? So even if you have a block number, how do you find it? And by the time you're done looking for it, the fraudsters have taken advantage. So unfortunately, by the time that family discovered, most of the titles had been transferred. And then you're like, so this person worked so hard for nothing, and her children won't even benefit from this, because once the property passes to a stranger, it's much more difficult to recover. Yeah, we have cases where a widow is sent out of the house because apparently the customary heir is the man of the home now. Yeah, and so I did a case where a son was chasing the mother out of the house. Can you believe it?
I pushed you for 9 months, and then you do that stuff to me. Oh my God.
So the things we see as lawyers are just far too many. Cases where a business partner takes over the business and completely forgets about the family of his partner. Like, you carry on, you run this business, you're deriving benefit, and your the children of your partner who used to make this money together with you are struggling. But all that is because people don't document. You don't do a will. And when you do a will, it takes you to a particular mindset, because you start to look at relationships differently. Lisa, if you know that this person is going to be the executor of your estate, you're likely to treat them differently. You're likely to engage them differently. To understand them better, to cultivate that relationship better. So there are so many things that you just derive from doing a will. Now, the disputes don't stop. But the law has also provided for intestate succession. So when you die without a will, what happens is we will convene a family meeting. And as you know, usually the loudest uncle will come and carry the day. And most likely, perhaps, this is the one person you would never ever have given anything under that will, or you never have given them authority. But they start scheming from the time they realize there's no will. So they will be the most well-behaved at the funeral. They will even contribute the most, perhaps, towards the condolences. They will be like uncle this, uncle that, and then what are they scheming for?
They have a plan.
They have a plan ahead. So what happens is these people will then convene a meeting. It's worse if you have more than one partner. In such cases, that's where relatives really take advantage, because they will say, now for you, you can't, Lisa, you have 3 children. You have a 15-year-old, this one has a 2-year-old. They need more. And since you're conflicted, you won't be able to do a good job. So now let's appoint so-and-so's elder brother to be able to be an administrator. So slowly they start to creep into your estate. But they have a selfish motive. They have an ulterior motive to take what you worked so hard for. So you'll go through those meetings, take minutes, go to the Administrator General's office, get a certificate of no objection. You'll be amazed at the point when you're having the minutes, when you're doing that meeting with the Administrator General, if they realize the estate has nothing, they will not be interested. If they realize the estate has properties, that's when they'll be interested. So then you'll go to court, get letters of administration, and the law has now prescribed how we distribute that estate.
If there's no will.
If there's no will. So it will say, the law says that your spouse gets 20% of the estate. Now, 20%, again, it depends on whether you loved her that so much that you should have given her much more. Or perhaps it was complicated and 20% is too much. Because there are people who have separated but they've never divorced. Now imagine this woman comes back into your family, mixes, because there's a 20% to claim. You didn't leave a will to clearly say, this one we have no more business together. She's still a wife for all intents and purposes. She gets that 20%. The children get 74%. Then you have dependent relatives. You know dependent relatives?
Cousins.
Those cousins, nephews you look after. If they depend on you for school fees, clothing, what? They're entitled to 4%. Now 4% may seem like a small percentage, but depending on the estate, that can be a huge, especially if your intention was really to support them for a short time. Yeah. So that 4% goes to them. Then 1% goes to the customary heir. Yeah. So you realize that even if there's this one child who had looked after you, treated you really well, that perhaps you needed to give special attention or much more, the law says they all share equally. Yeah. If you have more wives, they all share in that 20%. The only difference now with the amendment of the Succession Act is that the matrimonial home is now protected. So that for the wife, the woman who is in the home takes that, yeah, that matrimonial home. And so you find that people with multiple partners, yeah, everyone will earmark their property, yeah. The law has also provided for minors for education purposes. It has provided for disabled children that up to a certain age or when they marry is when we will say we will not provide for them. But as you know, when you die without a will again, people are going to be selfish. They're going to be like, why are we giving that one so much? Whose fault is it that for me I went to school before them? You get it? So you unnecessarily you expose your family to disputes, and you never know who people truly are until you're gone. Yeah. If the dead could speak, they would be shocked by the things that happen.
So Damalie, you talked about the business side of things, yeah? I have a business, I have shares and stuff like that. How do I ensure that my dependents also benefit, especially if you have like partners and stuff like that? Yeah.
So again, I think that in Uganda we avoid relevant but uncomfortable conversations. Yeah. So what happens is when you're starting a business, I think we'll talk about family businesses differently. Yeah. But now here we're talking about businesses where you're independent people, you all have your different families. So what usually happens is that you come together and start this business, and you never really stop to ask yourself or yourselves these particular questions of what would happen in the event that I have died. Yeah. And so you take it for granted. You take it for granted that your partner will be reasonable. You take it for granted that, oh my God, she likes my children. There is no way she cannot look after my children. Yeah. So for businesses, it's extremely important for you to don't have generic documents. Because what usually happens is you come to the lawyers, we give you an invoice, you're like, that's too much. Can we just use the template? So we use the generic documents. But if you are thinking in terms of estate planning, then you want to have very, very specific documents for it. So if it's a company, your public documents might have your general understanding, but you can have a shareholders agreement. That shareholders agreement will spell out exactly what your responsibilities are, what would happen in case of incapacitation, what would happen in case one dies, what would happen in case of so many scenarios that would happen for business. Because if you've not provided for that, if it's a partnership, God forbid, that relationship sort of ends at the point you're dead. Yeah. And that doesn't help you. You've invested. So let's say for a law firm, your brand, your name, your clientele, yeah, still exists, and the firm is going to ride on it for a very long time. So it's only fair that there's provision for your children. Yeah. But if you've not had that conversation, it's just going to be like, you're not contributing anymore. Yeah. So you're dead, that's it. For companies, the law has sort of prescribed, there's something called transmission of shares. Okay. So when you die and you are a shareholder in the business, the shares go to your legal representative. So if you left a will, the executors. If you didn't leave a will, the administrators. So they become the de facto owners of those shares, and then they pass them on to the beneficiaries. Okay. Yeah. Under that distribution scheme that we've already talked about. So if you had done a will, you would say my shares in this company go to so and so. Yes. So they will go on from the executor to those beneficiaries. If you didn't leave a will, most likely those shares, because you realize if you had shares in a particular company, you may not register all your children as the beneficiaries. So sometimes you may find that the administrators will just say, in the interest of everyone, let's sell those shares, which also sort of defeats the purpose for which you held those shares. So again, that's why you have to have a will, and you have to have this conversation with your shareholders to say, what are we going to do in the event that I'm dead? Now, when it comes to family-owned businesses, let's say you're a husband and wife, we will still do that transmission. But what I recommend is that as a couple, you should have a family charter to say, okay, so this is our business. We're running a social media business. Yeah, we're running a perfume business as a couple, and this is how we want to. So the family charter will sort of make provision for all the assets. Yeah, we'll have all the assets, the businesses, the land, the what, all the assets that you have. And it will get in depth into what is the vision of the family. Of course, that takes a lot of leadership from the husband especially. What is our vision as a family? What are our values? The things that we take time off to plan for companies and organizations.
We should do it for
we should do for our families. So we sit and say, as a family, this is what we want our legacy to be. This is our vision. This is how we want to raise our children. These are the communities we want to grow. Yeah, and so once you have that mindset, then you ask yourself, how does this align with the businesses that we're doing? You realize then that even the businesses you're involved in will not be random. Even when it comes to charity, it won't be random because everything aligns with a long-term view that the family has set. So once you have spelled that out, then you will ask yourself, we are, as a couple, there are assets that we will hold that are personal, and then there are assets that we will hold together. So we will say, for the things that we say, these things are yours, you choose how you deal with them, that's okay. These properties are for the family, and this is how we're going to deal with them. So you don't have cases where a will is being read, and then you say, but yes, Steve, I thought we we were holding this property differently. So that family charter sort of helps to bring transparency to how you own assets. Of course, that works best when you have a good relationship. And if you can strive, if you have such a relationship, make the most of it and try and have that conversation. But even in cases where you don't have a good relationship, because at the end of the day, you're all working very hard. And it's usually not necessarily for yourselves. It's for your children. So can you agree that we shall disagree on certain things as a couple, but for particular assets, this is what we're going to do. I did an agreement, a couple's framework agreement for a particular family. So this particular lady found out that the husband was having an affair and had had a child with a mistress. And her concern was, we're working so hard, and she's the one who was bringing in the most money. It's like, God forbid something happens. What is going to happen? That
she's going to
go to the other person.
She'll enjoy.
So how do we make sure that we have a general agreement on how we own these assets? There are things which you're going to have, which a portion of which can go to the other lady and the children, but for particular assets, I have to be covered. So it may not be the most comfortable conversation to have, but you would rather do that than leave it to chance. So there are so many other tools and so on when it comes to businesses.
Wow, I have so many questions. But what mistakes have you seen that we make when we are doing estate planning that we can point out? Is there anything that we have not yet brought out?
The first mistake is not making a will, right?
Of course.
So there is no estate plan to start with. The other mistake is, for many mothers especially, what do we do when you do that will? You distribute, even fathers, you distribute all the assets to your children who are below 18.
King, Rain, what?
You're like, that property goes to Rain, this one goes to... And I like that we do it from the long-term perspective of, I'm going to be here for a long while, like at 85. Will happen later. But God forbid something happens, because when you have stipulated that, it means that it must be distributed as you've said. So the executor must get those properties and transfer them into your child's name. But there's something called sudden wealth syndrome.
Sudden wealth.
Yeah. Of you've never dealt with this much wealth.
Money, yes.
How do you as a child deal with this kind of wealth? Yeah. And how do you as an executor protect yourself legally without being taken to court by this child who says you've refused to give me
my
what
property.
the will provided for? Yeah. So for parents making wills for minors, you have to think through it and ask yourself, is this child capable of holding this much wealth?
Yeah.
If not, what other instruments, what other tools could better save this property? Could a trust work better in that particular case? A trust, in my view, would work better. Could life insurance also work? Yeah. And so you start to realize that the distribution is not just
Giving.
It is very thoughtfully crafted, based on the risks that your estate has, the challenges that might arise, and the needs of your beneficiaries. So that's one of the things. The other mistake is distribution, even when they are adults. That whole notion of a will should just distribute, I totally disagree with it, because I have seen in my experience, 2 years later, everything vanishes, yeah? And it's very, very disappointing. When we've started off, so we hand over the probate once the court has given, or the letters of administration, and then 2 years later, you can't explain where this money went. And part of the mistake is that we don't even have enough literacy for our beneficiaries. Yeah. So we work so hard, and even for families where the children are old enough, you don't involve them into these conversations. Yeah. There's someone we told, but you've sold this property. Instead of just spending this money, how about you take out this insurance policy? Yeah, at least secure your children's future and secure yourself. How about you take an annuities program for this particular dependent? Yeah, that way you're sure every month they will have something to use until they are dead. Yeah, but guess what? At this point, when we're engaging with them as your beneficiaries for the first time, it's very difficult for them to see things from our perspective or from their parents' perspective. They just think your role here is to get me letters of administration. Once you've given me that, you carry on. So I find that the mistake we make is not educating these beneficiaries enough on how to wisely use these resources, on what alternatives are available. Yeah. Instead of just distributing, instead of just selling all these properties, I feel that we lose value from doing a will if we've not empowered them. From a mindset point of view, but also from a financial literacy point of view, on how they can use those properties. What other mistake? So many assumptions we make. For example, for jointly owned properties, there's that big misconception: joint tenancy over tenancy in common. A tenancy in common assumes that we all have individual interests in this property. Yeah. So if I die, that share is retained by my estate, and then this estate. So the estate is basically severable. Yeah. So Lisa gets her share, I get my share. Yes. Now, when we're registering our properties, if we own, if we're buying, let's say as a group of people or as siblings, we just simply say, you register as joint tenants. And then what that means is that only the surviving people retain the entire interest. And yet, ideally, if you don't intend for the surviving people to be the only ones to benefit, you need to do a tenancy in common, and it needs to be very clear, and you need to document it. What other mistake do I find? Assumptions of marriage.
Yes, cohabiting.
So you cohabit, you have children, you buy assets together.
Side eye.
You work together.
Yeah.
Your families are known to each other.
Yes.
You go for Christmas at their side. You also visit the other side. And then you think that you are married. And you're shocked when the lawyers tell you after those letters of administration that there's nothing that belongs
for
to
you.
Yeah, there's nothing for you here because you have no marital
Something, yeah, legal
status.
Yeah.
You have no certificate of marriage. You're not traditionally married. You have no civil marriage. There is no marriage that is recognized under the laws of Uganda that you contracted with this person. And then you say, but see our photos together. And so we're like, we can't use that.
We can't use photos. We have children.
We can't use photos. We have children. It's not enough. So remember, the law provides for a spouse. Now, if this person did a will, you'll be lucky because under the will, they can give you something.
If their person has written it.
Yeah, because in a will, why a will is called a will, it's your wishes. So I can give Lisa my property, even if we don't have a formal relationship.
Yes, that's true.
But without a will, we have to go back to that list. Are you a spouse?
Beneficiary?
No. Are you a dependent relative? You're not a blood relative.
You are dependent.
Are you a beneficiary? Are you a child? Are you a linear descendant? You're
nothing.
Not. So what keeps you there is, I'm here for the sake of my children.
Oh my God.
So then you have an appeal task to prove that you contributed
to the
properties. To be like, guys, on this day, I'm the one who bought this cement. I'm the one who did this. And yet, guys, guess what? It's so easy to get married. Yeah?
You don't need a big function.
You don't need a big function to formalize your relationship. But we get lost in this whole trend of it must be big, it must be this, and you lose sight of the bigger picture. I'm not saying don't do it, but try and formalize. I know a couple that first did a small civil marriage and then they organized the big thing. Yeah. If it matters, if you're investing, if you're doing things together with this person, you need to formalize it. Otherwise, we will just say sorry, but we told you. And
people will take advantage of that because they know that you're not married.
Exactly.
Every uncle will just throw you out.
Yes. Yeah. So that's another
myth.
Anyway, we could go on.
There are many. A number. Yeah. So guys, Banange, please, women, please protect yourselves. My heart goes out to you. Please try and do that. Okay. Yeah. So we talked a bit about blended families because it can get quite tricky, you know?
Yeah.
Then he got married again. Then, how do we navigate that?
That's interesting. That's a complex situation, and it depends on where you lie. Yeah. The common denominator could be the man. Usually it's the man. Yeah, but we know in some cases it could. So first, let's understand that beyond the relationship, there is the individual. So you're a woman and you have children from different partners. There is your part to play. So how do you make sure that, at least for the assets you have, your children are protected, regardless of their partners? Yeah? So if it's your own properties, you can prescribe, through a will, you can prescribe how they're distributed. Yeah? Now, how they benefit from their father's estate, if there is no will, remember, we go back to that hierarchy. We will say if you're a linear descendant, this is what your percentage would be. So your children would have a right to go and line up. Whether you are married to that man or not, they have a right to claim a portion of their father's estate. And so they would line up with the rest of the children and vice versa. But what is recommended is transparency. Because oftentimes we find out about these families, these children, later.
And it's too
You find there's a will and this person didn't even mention that they had children elsewhere. And we have to go through the embarrassment of taking your children through a DNA test to prove that they're yours or not. Yeah. And for the men, I think that it's extremely important. If you ever suspect, and I know they're going to say, no, I would rather be dead than find out that this child is not mine. But there's a situation where a family in North where this man almost mortgaged their family home for this woman. Because she said she had given him sons and he had daughters previously. And so when he died, they found out he had signed documents. Thank God he had not yet mortgaged the property. When they did a DNA test,
They were not his kids.
they were not his children.
Oh my God.
Yeah, so if you doubt whether these children are yours, you might as well do the DNA test so that you avoid the embarrassment. Yeah, okay, you'll be dead, so there'll be no embarrassment, but
still, your name,
you don't have
your
to
legacy.
take your legacy. Yeah, so
Hold on, something has moved.
and then we have cases where someone lived all their life denying that this child is not theirs, only to find out upon death that this child was actually their daughter or their son. So for people in those relationships, as much as possible, be transparent.
Yeah.
Be transparent. If you won't be transparent to your partner, which is not encouraged, at least let there be people that know. Let your will stipulate clearly and help us identify these people. Like, where do we start? Yeah, where do we start?
Yeah.
If you can avoid it, I'm telling you, Lisa, if you can avoid being in a blended situation, being in a polygamous relationship, it's much easier. Because we found that families in monogamous relationships, they might have a few issues, but they won't have as many complicated issues as when people are in polygamous relationships or in blended families.
Yeah. But then sometimes it just happens. Like, for example, my mom died, my dad got married again. There are us, then the other kids you get. So they sometimes like you get.
Can avoid it.
We pray that the people are wiser.
Yes, that's true.
In this
But
situation.
remember that we talked about initially the family charter and the vision. As the head of the home, you have to think through, like, what is your legacy? Yeah. So in circumstances where you've had things like that, where it's justified that certain things happened and you have children from different relationships. Even for you, it's important to have a clear vision for your family to say, okay, this happened, but how do we build harmony? How do we build unity while you're still alive? So that at the end of the day, even if they are step siblings or half siblings, there's going to be some harmony and unity. That is, because not all blended families have issues. Because it really depends on how
the
leader. It depends on how the leader managed that relationship.
And I think if people are old, like if people have the conversations, I think it's better. When you're alive, you can have conversations clearly, ask a question, so that people know that you know what will happen. So that you don't wait when again now you're not around and fighting and beating each other.
That's true. And another instrument that for such people you can use, there's something called a gift inter vivos.
Gift inter vivos.
So that gift is really a gift to, it's a distribution when you're alive. So if you find that you're at a particular point in life and you feel that you're now safe enough, your children are responsible enough, it's okay for you to distribute these assets while you're alive, so that everyone knows. Everyone, if they need to take possession, they take possession while you're alive. Of course, you can put all these terms and conditions. You can be a co-owner, you can say no transfer unless I'm dead, But if you are at that point where your children can responsibly manage these assets, you don't have to hold on to them. Let people know that this particular property belongs to so and so, and they're the ones using it. And that's also
I'd never heard of that. Okay. Now, children with disabilities or things like that, you find that maybe this is your only child, but they have a disability. How do parents pass on those estates to such?
So again, it depends on the disability. If it's mere physical disability, that child is as good as any other person. If it's mental disability, then they have to have, there's what they call a guardian ad litem. So a guardian ad litem is a person who looks after minors, yeah, or what they call a next friend. So that person is given responsibility to look after that person and until their circumstances change. So for such cases, because you realize those are special needs people, if you leave it to chance, they can't express themselves. They can't show how vulnerable they are. It means that you really even have to take extra care in terms of planning for them. Yeah, you can't leave it to chance, because since they can't express themselves, they can't fight for themselves, most likely they're going to be taken advantage of.
That's true.
So you need to identify without you who would be that guardian. Yeah, how do you then, without telling them that, by the way, in my will this is it, unless they're really free to do that, how do you empower them? How do you nurture that relationship so that they take your place in the event that you're not there? But also, how do you make it easy for them? Because special needs children usually require special attention, extra care. So as opposed to leaving it to chance, you make some extra provision for the guardian looking after them. You have to say, I don't want you to stress about money. At least there will be a nurse to care for them. There will be bills. The bills will be paid. They don't feel like it's a burden on their part. And then you write it down. Make sure that you write it down. If you can take out insurance products for these children, take them out.
Okay. All right. And now we've seen like many people who live, maybe your father leaves you something, but then you're paying so much tax on it and all these things. Is there a way we can make it?
So that's an interesting question. So when property passes on to you, let's say there's probate, under the will they give you this property, and now that property will go from the executor's name. When they're doing the transfer, it moves from your father's name or mother's name to the executor's name. Then the executor will transfer it to you. Now, at the point they're transferring it to the executor, there is no cost. There's just a registration fee. There's no tax. The point they transfer it from the executor to you, you're going to pay the same tax a stranger would pay if they were buying that property. So now that you have that knowledge, what would you do differently? What you could do perhaps is, instead of buying properties in your name, you create a trust and put those properties under the trust. Immediately, you put them under the trust for the sake of your children. I don't know if you get what I mean. So when the property is under the trust, you don't need to transfer it. You realize?
Yes.
So it will appreciate in value, but you're not going to have to pay stamp duty because the children are already provided for. So that's one of the advantages of a trust, that it takes advantage of time, confers ownership in quotes to your beneficiaries without exposing them to that liability. And eventually, if let's say you've said this trust should subsist for 30 years. It's at that point when they're doing that sale that then they'll be forced to pay some tax. The trust will pay tax. Maybe it will be called, it will be capital gains tax on the difference only in terms of the value. So an instrument like a trust sort of helps with that.
Guys, the information, I feel like writing in case I forget something. It's really been nice. Okay, so we've talked about money and assets and all these things. And of course, the Bible tells us a good man leaves an inheritance for his children's children, you know. In what other ways can families leave a good inheritance? That's not only money.
That's a good question. So we know that wealth is fleeting, right? Like I've shared, this wealth really disappears very quickly. But even the ability to preserve that wealth depends on things more than the wealth, which leads us to values. So it said that the difference between inheritance and a legacy is that inheritance is about the things you leave behind. Legacy is the things you leave within. So the ability of your children to preserve your wealth, to preserve your legacy, is not just about the material things.
Yeah.
It's about what would daddy want? What would he have said in this particular situation? What would he have done in resolving this dispute? Yeah. So it's again, remember the family charter we talked about. Yeah. Even if you don't have a family in quotes, can you have values on your own? Even if you're a single mother,
live by, yes.
To say, my children, my children will be taught of the Lord, and great shall be their peace.
Yes.
So do they know the Lord? Yeah. If that's important to you, can you build that? What things do you do to make sure that you build that in them? If you say, I want my children to be hardworking, because to be able to preserve that wealth,
they need to have
need to have the skills. They need to have they need to know that things come from working. So have you built that in them? If you say that they need to be learned, how much are you exposing them? Like, do they think that your property in Chijavijo is the biggest thing, or have you exposed them to bigger empires and estates? So that then they're going to add value
and add on it,
to what you have done. The only way they do that is through the values instilled in them. You know, charity begins at home.
Exactly.
So if you've not instilled these things in them, they say train a child in the way that they should go, so that when they grow, they will not depart from it. So that's why I say that estate planning is not just about writing a will where you're distributing these material things. It's sitting down to say, 20 years later, or after I'm long gone, my children will say, Mommy left us these assets, but Mommy also taught us these things. Mommy would never have done this. Mommy would have done this. Mommy empowered us this way. And it is those things that are going to ensure that my legacy is passed on. Without which, it's going to be guesswork. Are you sure Mommy would do that? It's going to be guesswork. So then you start to realize that even the conversations you have with your children
are different because you have a plan. And
you have a plan. If you think this child is going to be your heir, not these customary heirs that we talk about, who are very docile and just have a title. If you want this child to be the one that takes your place when you're gone,
what does that really mean?
What does that really mean? How are you making sure that you train them to be leaders? How do you train them to be kind? How do you train them to create harmony and unity in the family? Respect for one another. So things like that then start to shape your conversations, your perspectives, and the way you view life.
I love that. I love because when you have that plan, you're able to think through your life properly and what you want, the legacy you want to leave. I wish we'd all think about that because it helps you live differently.
True.
Many times we want to think of only here, now. You know, and even there are people who are saying, the children will make their own money. Even me, I suffered, I struggled. In this day and age.
I know.
No, it shouldn't be like that. Okay. So as we conclude, what advice would you give? Any parting shots to, families out there, on everything we've talked about? Give it to them.
So before I give the advice, there's the part that I did mention for people who have mental incapacity. That many people get exposed. You get into this state of mental incapacitation, and then we have to go to court to get you an order, which is more expensive. It takes time. The one instrument that could work is a power of attorney, where you appoint the necessary people to help you manage the estate while you can't. So what advice do I want to give you, viewers? One is let's normalize the conversation around estate planning. It's not about death, guys. Stop lying to yourselves. Like when you start talking about estate planning, when you start thinking about wills, you're not about to die. We say that with long life, God is going to satisfy us.
Tell them.
So why do we forget that part? So let's normalize the conversation. And you realize that when you normalize that conversation, you're going to think legacy. You're not going to think YOLO. You only live once, and you spend all the money. No. you're going to think long term, you're going to think legacy.
Yes.
You're going to build deeper and better relationships. Let's also think about values in children. That as we are working so hard, we are amassing this wealth, we need to ask ourselves, do our children have the capacity to take it up, to grow it, and add value to it? And so can we be more present as parents? Can we have relevant conversations, not just buying, you know, toys and what, but what else can we do that will impact our children to think differently, so that then they will say our generation of parents was better. Can we take action? Now that you've learned, I've given you free legal advice.
Please.
Okay, you had to buy the MBs. It's worth it.
But still,
But can you take action?
Yes.
Yeah. It doesn't cost you much to write a will, to have an estate plan, to do a trust, to have a power of attorney.
Yeah.
Don't
What's the
wait
cost
for a
actually for
crisis.
someone to start? Is there?
It depends.
It depends.
It depends, because as you can tell, this conversation has taken us through different aspects. Yeah. You go to a lawyer who is going to just tell you, oh, give me 500 and I do it for you. But real value comes from intentionally, deliberately, and critically thinking about your estate and the issues, the risks around it, and then coming up with solutions that mitigate those risks. Otherwise, I will give you a random figure and then it won't make sense. So let's do our wills, let's have an estate plan, let's have these conversations. And subscribe.
Good. Okay. Thank you, Damalie, for this amazing conversation. I personally have learned a lot. Please, guys, make sure you take steps. Like just say, take action. You've known, knowing is good, but wisdom is putting the knowledge into action. So please, first things first, get a professional. Yeah, go see a lawyer. You know, go see Damalie. Tara Advocates for me has really been a good resource, and I really love that you guys are so professional in the way that you do the things. They are fast, structured. My experience has been really good. So please take action and then have conversations with your family members. I think for me that's key. Communicate as much as possible. Build that unity so that by the time all this is taken into, you know, action, like things are better, smoother, no fights and stuff like that. I hope you guys have enjoyed this video as much as I have. Let us know in the comment section, do you have a will? You know, and what are you going to do about it? My name is Lisa Kusima. As always, I'm here to inspire.